Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk about when you are or somebody is signing the durable power of attorney, one of the most important requirements, and that is they must have the testamentary capacity to sign the document. I can't tell you how many people come into my office and they say, well, my grandma is not doing very well. She's unable to, understand. She comes in and out. She's got dementia and she can't pay her bills anymore. And I need to get a durable power of attorney from her so that I can help pay her bills and write the checks and all that. Well, the first thing I ask her, the person who's in my office, is I say, well, does your grandma understand, number one, what a durable power of attorney is, and does she understand and agree that you are to be the agent? And many times they will say no and no. Okay, so first things first, you cannot have a valid, durable power of attorney unless you have testamentary capacity. The person signing it cannot be unconscious, cannot be in a state of dementia, cannot, have forgotten everything and doesn't know who you are, and cannot be incapacitated. So first lesson is have the durable power of attorney signed before the person becomes incapacitated, if that's at all doable, which in most cases it is. But if in the case where the person's already incapacitated, the bills are piling up, the mortgage isn't getting paid, and there's all kinds of other problems, the issue then is, what do? Well, you're going to have to petition the court for conservatorship. Okay, conservatorship over the person. And that would be your grandma. In the example that I have given, that would be what would be necessary. So the court would then, you file the petition, you get the evidence, you do the arguments, and then assuming that everything goes well, you would then let the court know, or the court would let you know, and hopefully approve that you or whomever, is designated will be the conservator over this particular person. And the conservatorship can be very broad, can be narrow. It really depends. And it's the only way. You cannot get a durable power of attorney for someone who's incapacitated. And the same thing applies to an advanced healthcare directive. If there's no capacity and the person signing it, it's not possible to get it. You can't hold the person's hand and have them sign something. They obviously, for the most part, if they are incapacitated, they couldn't sign anyways. And so there's a whole issue on what is capacity, what's involved. Realistically, there are ways, even if a person has dementia or Alzheimer's, to have testamentary capacity. But this particular video is for the person who has absolutely no capacity for signing or understanding what it's for, have to go to court, have to do the conservatorship, and you have to get the conservatorship over the person in order to proceed forward. So if you like the video, click like, subscribe, and also I will give one free consultation for anybody in California, no matter what the estate issue is. So go ahead and give me a call. I'll be happy to help. More on the coming videos.